delighted to welcome you. This is yet another of our great speakers in our Surveillance Democracy series. And it's my delight to introduce today Professor Paul SCHWARTZ, who is Jefferson P. Kaiser Professor at UC Berkeley Law School. Professor SCHWARTZ is one of the world's, and I mean this, and this is absolutely without hyperbole, one of the world's leading scholars of information privacy law. So it's a particular privilege for us to have him here joining us in considering issues about surveillance, and particularly in an international context between the United States and Europe, which has been very significantly in the attention of policymakers across the world over the last 2 or 3 years, especially. Professor SCHWARTZ is a graduate of Brown College, Brown University, and Yale Law School. He is currently co-reporter of the American Law Institute's Restatement of Privacy Law Principles. He has written, as I've mentioned, some of the most important works in the area of information privacy law, and has the leading textbooks in the area. So this is the work is occupies some 50-some articles, a handful of books. It's quite prodigious. So please join me in welcoming Professor SCHWARTZ.
Thank you for that wonderful introduction, and I should mention I'm Jefferson E. Kaiser Professor of Law, and when I received the chair, which was a great honor, I then did some research into Jefferson E. Kaiser, and he was a pioneering lawyer, both graduate in the wine industry. So way back when, in the 40s and the 50s, he was very instrumental in developing the California wine industry, and he was also a San Francisco city official and one of the first Americans to protest against Nazi Germany. And so in 1933, right after Hitler became Chancellor of Germany, there was a German Day celebration in San Francisco with Nazi banners, and he was a city official and he refused to participate in the ceremony. So a great man, and I'm very honored to have this chair in his honor. Today I'm going to talk about my paper on comparative contractual privacy law. And so what I'll be doing, and here's the roadmap, that's Berlaymont, which is one of the main buildings for the EU in Brussels. It's without the scaffolding. When I was back in Brussels about 3 years ago in the dead of winter, it had this huge scaffolding on it, and they were removing the asbestos from the original construction. So the asbestos hopefully is gone, and there's the building where there are a lot of European Union bureaucrats. So I'll be talking about comparative approaches to contract, not initially about privacy, and giving you a quick snapshot of that. And then I have my 4 assessment factors. I'll talk a little bit then about the U.S. approach to privacy and consent and contract, and then EU approach to contract and consent and privacy, and then make some predictions for the future. By way of introduction, I have to say I think achieved something unique in this paper, because when I circulated among people in the U.S., they get very confused. And when I circulated with people in the EU, they get very confused. So, and I think that the difficulty is that the EU people don't really understand the U.S. approach to contract, and the U.S. people don't understand the EU approach. So both of those descriptions, people have told me, they think are reasonably accurate. But then when they get to the other section of the paper, not dealing with their legal article, various professors told me, I don't know what you're talking about. So I'm still thinking that through. Oh, and very exciting, because I'll be talking about the future. I have got my digital crystal ball that I brought with me, and so we will peer into it and try to figure out what is the future for privacy contract. And then also to illustrate the future, here's the cover of one of my favorite Leonard Cohen CDs. I don't know if there are any Leonard Cohen fans, but it's a great CD. It's the one where he started figuring out he should stop singing and kind of just talk his way through the songs. Okay, so let me now talk about my 4 assessment factors. And again, this is a paper, Comparative Contractual Privacy Law, which is under peer review for the Journal of Legal Studies in Chicago, which I also presented in an earlier version at a conference at the University of Chicago. So we'll start off and we'll talk about comparative contractual law. So EU has seen strenuous efforts to protect consumers, and so this is something that when I started the paper, I didn't know that much about contract law in the EU. I knew a lot about EU privacy law, and so it was kind of fun to be a first-year law student again without having to take exams, and to go back and read a lot of EU contract law. So one thing is, in Germany, for example, I found out they don't have a notion of consideration, so that was kind of cool, right? That seemed like it was a plus. But then the downside was it was insanely complicated, I found, even by U.S. standards, to try to understand German contract. Another thing that I found out was that in the common law tradition in the UK, there's been a huge influence of EU directives, and that arguably common law contract in the UK looks more like continental contract because of the influence of all these many EU directives. And at the end of the day, what the takeaway is in the paper is there has been a tremendous effort in the EU through a series of directives and in other ways to protect consumers. So there's a distance selling directive, there's a gray list of contractual terms that are largely disfavored in the EU. And I really didn't see anything like that in the US. And so in the US, although there are attempts to strike down unconscionable contracts, and there have been other efforts, we largely live in a realm of arbitration and boilerplate, and there are not strong efforts to protect consumers against onerous, standardized contractual terms. And here, wonderful work by Peggy Radin in boilerplate, and all kinds of other articles. And so the reality is, most of us don't bother to read contractual terms. We confront a variety of standardized contractual terms every day and simply sign them. And most contract terms are not negotiated, but they're taken as legal terms, and we largely take it. And the U.S. courts largely uphold those terms, including arbitration clauses. Okay, so here my illustration is a beautiful field in the south of France with sunflowers and lavender to show the more peaceful and consumer-friendly EU approach. Okay, so now we're gonna shift and we're gonna talk about contractual privacy a bit. But before we do that, I decided I would come up with 4 assessment factors so that I would have a relatively concise way of getting through all the ins and outs of the different systems. So what I'd like to do now, which I maybe don't do enough of in the paper, where I just pull these things out of the hat, I guess, is talk about what this has to do with contract and what we would expect the answer to be in contract. So relevant harms. And so the notion is when the U.S. looks at contractual privacy and consensual mechanisms, what kind of harms does it police against? And so here, if it was really largely a story about contract, it would be the same story as in contract. And so what are contractual harms? Well, there are things like you didn't get the benefit of the bargain, so I guess really the classic one. And what do you do then? I guess you just kind of restitute, right? And then there may be kind of things that go down the road because you can get the benefit of the bargain, and sometimes you include them too. Second of all, legal institutions for policing. And here, the standard contractual story would be it's kind of Joe and Jane, and then they go to court. And there's a common law court, and it enforces the contract, where police reads the contract and polices it. And so the enforcement mechanism in place, were this to be really a story about contract, would be a court. And then finally, impact of technology. And so here, well, I guess if it's really a standardized story of contracts, the notion would be, well, maybe it's a contract that you do online and you check off, but technology itself really doesn't change the story of contracts. So then, what's the U.S. approach? So this is a story in large part about the FTC or others. So we actually don't have a lot of contractual privacy. We have a kind of odds and ends of cases. In our the Daniel Solo Paul Schwartz casebook, I think we've got 2 that we talk about. There have been some others. Largely, privacy policies are not upheld as contracts. And if they, to the extent they are, they're usually one-sided contracts that the Googles and Facebooks and Microsofts of the world draft without a lot of input from anybody else and not a lot of bargaining about terms. Nonetheless, the first step of the story is that a number of state organizations, institutions have obliged and required people who collect information to state a privacy policy. And so this is also a story about privacy federalism, because it's something that the FTC has required, and it's also something that we find in California, in Cal-OPA. So the FTC, as part of its enforcement of its unfair and deceptive trade practice jurisdiction, largely requires entities that collect information to tell their affected parties what they're going to do with the data. Similarly, in California, there's a requirement for online sites to have posted privacy notices. And then there are all kinds of various other little obligations and sectoral laws and other little niches that say, have a privacy policy. As a result, American lawyers know if you have a company and they're collecting personally identifiable information, you need to have some kind of policy, right? Same thing like in the private sector, if you want to have your app on the Apple iTunes store, you're going to have a privacy policy. So the first step here is you have to state what you're going to do with the information. Next thing that happens is these statements get enforced. So if you promised X and did you do it? And if you didn't do it, then the FTC comes in and says, it's a broken promise. And then moreover, as part of our story of privacy federalism, what happens is under state mini FTC acts, also called UDAP acts, state AGs will come in and say, you didn't do what you promised. And in some instances, those mini FTC acts at the state have private rights of action. So you can have class action lawsuits. You broke your promise. Moreover, there are examples of development of substantive requirements. An example of that would be the FTC's unfairness authority, where the FTC comes in and says, well, you actually didn't break your promise, but what you did was unfair. And so an example of that would be the Sears enforcement action, where Sears was collecting a kind of information that was unexpected through a app that people downloaded on their program. And even though arguably they were telling about it to people in the boilerplate, it was very unexpected and it seemed unfair. So that would be an example of a substantive requirement. So if we pause for a second, this turns on consent, kind of agreement, because the data collector has said, this is what I'm going to do with your information, and then you've turned over the information. So it looks like consent. Is a contract? Well, we don't really know exactly in the U.S. I call it a contract light, L-I-T-E, because it's clearly far short of classic common law contract, but we kind of are approaching it and enforcing it. And so it's kind of, you know, semi-contractual. It's like the Diet Coke of contract, one, you know, calorie of contract from side of Austin Powers, right? Not contractual enough, but gives some privacy protection. It is not, however, equivalent to EU data protection. And it's kind of interesting because we're adopting this kind of common law form. It's as if you're singing an old song that people have forgotten the melody and the words to, but it approximates it. So that's the U.S. approach. Well, what then, what would I do with my benchmark if I had to think about this? And so one thing is, if we look at the institutions involved, it's not really the institutions of contract, right? That's the common law court. Instead, there are lots of institutions. It's kind of an interesting institutional study. Congress will pass laws, and we have the sectorial approach in the U.S., and there may be substantive requirements through things like the Video Privacy Protection Act, or you may be a financial institution. And if you're a financial institution, under the Gramm-Leach-Bliley, the financial institution would have to be very careful at what it tells the person whose data it is collecting. So really, really interesting institutional story, but it's not one of classic contracts. What about harm? And so here, right, we know what the contractual story is. We're doing this contractual-like thing in the U.S., but U.S. law is still very much in search of the theory of privacy harms. And the broken promise, in a way, is an easy one, but then at the end of the day, we're not really doing contractual enforcement. If you go back to contract, the notion is there was a promise, there was consideration, you broke the promise. So you get what is promised in the contract, and then maybe some kind of restitution, maybe there's some kind of contingent harm. But that's it. You enforce it within the four walls of the contract. The difficulty in doing that with privacy harms is, so Google has changed its privacy policy on you after it collected the information. Well, what's the harm? You still got to use Google, right? But now they're doing something different with it. And then you go in and you say, well, but it's my privacy. But then the U.S. really has trouble coming in U.S. law and saying there's an injury to you because actually then they shared the information with YouTube and you got a ad that you would not have otherwise received. So we're still very much in search of the theory of privacy harms. Regarding enforcement, it's not being enforced by classic common law courts, but what's interesting then in the U.S., at least compared to Europe, is broken promises can lead to extremely high fines. And so in the multi-million-dollar range sometimes, in addition to enforcement through fines, there's all kinds of other onerous requirements, such as setting up a formal data program inside an organization, agreeing to biannual audits that go on for 20 years. So high costs associated with the U.S. contractual-like approach. And then finally, what's the story about technology? The story about technology is not really that, the interesting part of the story is that these contracts are happening through terms of service and not through pieces of paper written on parchment and signed with a quill pen. But I think the interesting thing is that the entire framework is based on surveillance capitalism, a term that Shoshana Zuboff has used in a paper. And it's the notion that we're not exchanging our wage labor in a contract. We're not contracting to sell black acre or white acre real property. We are turning over our data, and in exchange for our data, we're getting services and products. And it's Facebook's, Microsoft, apps, and the technology, this kind of technological background makes this all possible, and it pre-exists from the moment we get involved with the whole contract-like apparatus. Okay, so now what is the EU approach? And this is the European Court of Justice in Luxembourg. So the structure that I talk about in the paper is the Data Protection Directive 1995 and the Draft General Data Protection Directive 2012. To present, we have the what's likely to be the final version, finally, of the General Data Protection Directive in December 2015, and it should take effect by 2018. So if we go back to my story about European contract, it's really a story about continuity, where there's great skepticism of consensual approaches. And the notion that because somebody has agreed to use a service, that they must therefore have agreed to all the kinds of trading and transfer and processing and use of their data that is buried in terms of service, or maybe completely not transparent. In the EU approach, consent is limited. It's carefully embedded in all kinds of legal and social structures, and it's quite limited in reach. And as really the big example of that is there are all kinds of inalienable privacy interests that are expressed in first the directive and now in the regulation. And so my example of that would be onward transfer restrictions. So the general regulation says you can only use information generally for the purpose for which is collected, and there should be purpose specification and limits on onward transfer. That is not something people can simply waive. It's inalienable, right? You just get it as a EU citizen. Data quality. The notion is the information should be commensurate, proportionate to the seriousness of the decision and the purpose to which the data will be used. You can't then consent and say, we live in an age of big data, and use lousy data to get a lot of data and make a decision about me. So there's all kinds of things that are inalienable. And here, by the way, is, thought I would put this up, some of this language on consent. This is Article 7 of the GDPR. And so look at the way they're policing it. Request for consent has to be presented in a manner which is clearly distinguishable from the other matters, using clear and plain language. You have a right to withdraw consent at any time. It shall be as easy to withdraw consent as to give it. And then moreover, a lot of emphasis on that consent be freely given. Utmost account shall be taken of the fact whether, among others, the performance of a contract is made conditional on the processing of data that is not necessary for the performance of the contract. Moreover, there's a long-standing skepticism in EU law of consent in things like the employment and healthcare and other kinds of sensitive contexts, where the notion is, we don't accept that you consent because you're an employer and you really don't have freedom to to not consent. Okay, so let's look at the EU approach. And we're on the way to the crystal ball, by the way. We're looking to the future. That's going to be exciting. So, as in the U.S., there's a wide range of institutions involved, right? Brussels, member states, not really in a common law type process where it's just about the contract. But I have to say, this is more typical of EU contractual law than U.S. law, where EU contractual law is very much embedded in openly, vibrantly in a social context. Whereas in the U.S., by comparison, our standard contractual law, we're really looking at Jane and Joe, and to a large extent, we're trying to filter out anything else in the world. It feels much more like the laissez-faire universe of the 19th century by comparison. Next, a well-developed sense of privacy harms. And the notion is it's about human dignity, right? It's about human rights. And so this is something that in the United States is really hard to grasp. It is based in part on a personality right, a Hegelian notion that there are some things that we all deserve simply because we are humans. And so for Europeans, there's a real sense that there's a there, and that these dignitary harms matter, and that they can identify them. I guess I would perhaps roughly compare it to the U.S. notions of free speech, where there can be all kinds of situations where Americans will kind of instinctively feel, you know, we don't want to limit this kind of speech. It's horrible, but this is really important. An example might be of that, Snyder v. Phelps, which is the Westboro Church case about picketing a funeral of a U.S. serviceman. And really just to protest the don't ask, don't tell policy that had been overturned. And the U.S. Supreme Court says there's all kinds of values, not high-value speech, it's abhorrent speech, it's going to humiliate the family at a time of maximum stress to them, but it's a good thing ultimately for this society. And so there's a real there, where on the other side, you could well imagine, like, really, we can't just limit this? This is the end of the world? This is really a slippery slope, right? But in the U.S., there's this, I think, very strong resonance to the First Amendment. Similarly, I think in Europe, there's this real sense, this is a bad thing, this is a dignitary harm, it matters, and we will enforce against it. Enforcement. So this has been an interesting part of the paradox that is, I guess, EU privacy law. At the same time, by U.S. standards, there have been very low fines. And my example of that is the Google privacy enforcement action in France, where Google unifies, simplifies its privacy policies for 60 of its services. Camille finds that it does so in a way that violates French privacy law, and after a long process levies a €150,000 fine. And so that's all they have in their toolkit at that point in time. That's the maximum fine they can levy. And it's pretty clear Google has probably paid its lawyers several $1 million to defend it, but Camille just can, the penalty is only $150,000. So that is going to change. There are a number of explanations as to why that may be the case, but part of which it may just be that more of a compliance culture in Europe. It may also be that on some level they just didn't take it very seriously. Okay, technology, the story is interesting because we have the same surveillance capitalism as is set up in the U.S. The same kinds of product services, high penetration numbers for services like Google, Facebook. I was over in Munich in 2013 to speak at the German lawyers conference at Juristentag, and people were lined up. I was jet lagged and I went out for a run, and people were lined up in front of the Apple store at 5:30 in the morning to get the iPhone 7. There was a line down the block. I went back later in the day after the conference, and the line was still there, and it had grown throughout the day. So people are using the same kinds of products and services, and it's really code as law, with all kinds of decisions being made in Mountain View and Cupertino, and they're being made before the regulators, whether in Brussels or Washington or Sacramento, have their say. And they're having this impact then on a real global basis. So that's kind of the story, I think, about thus far. And now I'm just going to take out my crystal ball, which I promised. And what's the future of contracting and privacy? And so let me talk about today and tomorrow. And this is going to be illustrated by a Beatles album, Yesterday and Today. Okay, not today and tomorrow, because I couldn't find a CD called Today and Tomorrow. But I found Yesterday and Today, so close enough. So in particular, what about this question, do we see a future of convergence or do we see divergence? This is, by the way, the classic question that comparativists, international law scholars like to ask. Are we becoming more like each other on a legal basis or less like each other? And of course, part of the question is how granular we get. Where do you focus the lens? And so let's see what my answer is. So, and again, I go back to these factors. So as far as institutions go, one of the really kind of interesting questions to think about is, do we wind up with a story? It doesn't look like it's the common law contract story where it's courts, right? We've broken free of that. It also doesn't look like it's going to be a highly centralized story. So I would, if I had to predict here, predict that we continue to have a significant role for the states in the story, and so it's going to be path dependent, right? In the U.S., the story why it's going to continue to be have large state inputs, it seems to me, is because of gridlock at the legislative level. Part of the story, though, in terms of institutions, is you're going to have more federal institutions involved. So the story of privacy thus far has been one about the FTC as policy entrepreneur. The story for the next 10 years is going to include the FCC, the CFPB, and other kinds of federal institutions. What that means for contractual or consensual privacy is it's going to be a messy story. There's going to be a patchwork of different kinds of regulations. What about the EU part of the institutional story? U.S. companies were largely happy, or at least the big ones, with the General Data Protection Regulation. It looked onerous, right? But I think U.S. companies felt, we're just going to be deciding with Brussels. We're just going to be dealing with Brussels. And all this tough stuff in it, the attitude for many companies was, there's all kinds of stuff in the directive that was tough, and they don't enforce us against it. So a lot of people were happy because they felt there'd be more of a single regulator. I'm doubtful about that, and I think the member states will continue to be jealous of their prerogatives and will continue to have a large say. Okay, what about harm? I think future divergence is likely here. I see testing of the FTC enforcement, which I discuss in the paper. I think U.S. companies will be more emboldened to not to settle, but to push back against the FCCs and state AGs, and so more litigation. Regarding enforcement, this is really kind of an interesting part of, I think, what I see in the crystal ball, because the Europe, the European Union heard for so long from the US, you have these high standards, but you don't do enforcement. So it's kind of like be careful what you wish for. And so it's clear that the regulation has really strong possibilities for penalties with 4%, 2% of revenue. And that model is from antitrust. And so that has been consciously adopted in speeches by European officials, such as the European Data Protection Supervisor, who said, we're going to make privacy like antitrust, and we're going to levy big fines as we do in antitrust. Finally, real question about technology, and so we have this surveillance systems, and by that I don't mean just the NSA. I mean the whole, borrowing from Zuboff's notion. This is the way the economy is set up. The same way, right, in the Karl Marx world, it was about wage labor and factories in Manchester, right? Today, the paradigm is Cupertino, or Mountain View, or Netflix, and viewer habits. So it's just the notion that the data is a really important product. And where does it occur? It occurs through software and hardware collecting it and harvesting it. And so it'll be interesting to see whether the kind of the Snowden summer of revelations is going to be a turning point in how we perceive the system. So I've got just 2 more slides. So I see already this is March 2nd, 2016. My prediction about this antitrust model coming in as confirmed. So German antitrust investigation now based on privacy. And saying that, so this has not yet been picked up by EU antitrust officials, but we'll see if it does. So German antitrust officials have said, you, Facebook, have leveraged your monopoly position in social media to gather an unfair amount of personal data from your users. So kind of privacy meets antitrust, and it'll be interesting to see if we have more arguments. And so now I'll be happy to answer questions and tell you about my favorite CDs or anything else.